Good morning, everyone. Welcome to the J&J Consulting Services receivership call. I appreciate everybody joining this morning and looking forward to giving you an update as to what we've been working on during this quarter. Today is September 24th, 2024, approximately 10 a.m. Pacific time. First of all, I want to give the typical disclaimers that we give. This call, nothing heard in this call should be construed as legal or accounting advice. If you have legal or accounting questions, we recommend that you reach out to counsel to provide answers in those areas. Any mention of anybody in this call should be considered innocent until proven guilty in a court of law. The idea behind this call today is obviously to give you an update as to what's been going on in the case. And so let's go ahead and jump right into it based on some of the questions that we've gotten from investors and love to answer for you. Can you give us an idea of what you and your team are working on for the clients at loss in this case? Just a point of clarification, the investors involved in this case are not considered clients of mine, but they are the beneficiaries of the work that I do, and I have a fiduciary relationship in order to maximize the return to investors in this case. So the things that we've been working on in this case, we've been marshaling assets. So we continue to discover new assets and take them into our possession as we do. We also are working on the forensic accounting to determine exactly how much everyone is owed, who may have benefited from the J&J scheme that should not have, that may potentially be third-party targets in the future, as well as litigation against other professionals and financial institutions. Next question is, why have we, the investors, not had the ability to be involved in any decisions? So that question is kind of a tricky question in that investors always have the right to have their voices heard. If you disagree with something that's happening, or if you'd like to be heard on something that's happening, you have the right to reach out to my office, of course, and talk to us about what's happening, as well as reaching out to the court directly as well. The court has put me in charge of the case as a fiduciary in order to manage the case. It would be very difficult if we had 1,500 to 2,000 people trying to make decisions on everything that goes on in the case, especially given that there's some information that does not become public that is part of this strategy in what it is we're working on when we sue third parties or in recovery of other assets. Next question is, who is Jennifer Floyd? So there are some names that you will see throughout: Jennifer Floyd, Jessica Abrego, John Hall, Milana Barkanoy, Sarah Bond, as well as other people from my office, Anna Preby, Josh McGraw, and others that you will see that may reach out to you from time to time. These are members of my staff and my team and my business partner, John, and are working very diligently on various different aspects of the case. And so you may have one of them reach out to you with questions. And I would ask that you would, of course, give them the same amount of respect and deference that you would give to me or anybody else involved in this case. We are working to try to maximize return to investors, as I stated. And so any help that you can give us when we reach out to you is appreciated. Next question is, how much longer will this case be open? That is an unknown at this point. We don't know how long some of the different pieces of this case will take. We do hope, of course, that we will be able to do interim distributions throughout the case, so you won't have to wait till the end of the case in order to begin receiving money back in this case. Next question is, what is the aggregate increase in recaptured money for this quarter over last quarter less expenses? It's approximately $3.2 million is what we've recovered in excess of the fees for this quarter. That number will continue to change. We do have a couple large assets that we've discovered that we are in the process of liquidating, which will increase that number pretty significantly. Can you explain the sequence of events that will occur after the forensic accounting is complete? Yeah, so after the forensic accounting is complete, there's a few different things that are going to happen. One of which will be a claims process, in which we will work with investors to establish their claim amount and be able to get that set. And once that is then set, then we will be able to file a distribution plan to begin making distributions to investors. We also look at third-party recoveries. So we may reach out to and sue third parties who got money that we don't believe are entitled to it, including financial institutions, professionals, and others involved in the case. Since the receiver gets paid professional fees throughout the process of receivership, will there be any final cost from the receivership as a percentage of the net amount returned to investors? or is it only fees paid based on time and rates? So we bill based on the hourly, based on an hourly rate, and that is how we are paid. It is unusual, although not unheard of, for a receiver to get some kind of success fee at the end of the case. But those are in extraordinary cases and are not common, to happen. So we will just continue to bill on an hourly basis as we have. Although there is a 20% holdback that is established by the Securities and Exchange Commission that will be paid at the end of the case that's being held throughout this case. Let's see, does the SEC work with the receiver at all during the forensic accounting, or do they do their own forensic accounting for their criminal case? So first, let me just clarify that the Securities and Exchange Commission works on the civil side, and they will get a civil judgment or will seek to get a civil judgment against the defendants in the case. We do work separately on the forensic accounting because we are not the same party. We don't, we provide the forensic accounting for our use in this case, but in order for them to prove their case, they have to hire their own expert in order to be able to solidify their own case. Next question having to do with defendants and parties. Why has Jeff Judd and others not been charged? Who gets charged and when is the decision made by the U.S. Attorney's Office, the U.S. Attorney in Las Vegas, and we have no say in that, and we really don't have any insight as to if or when that will happen. When will the Beasley trial start? I do believe the Beasley trial is scheduled to start next year. I don't know that that date will stick or if it will end up being moved in that case. Again, we don't have any inside information as to that. We only just get the notifications that are filed with the court. Do you have any updates on the criminal case against Matt Beasley and Jeff Judd at all? I just attempted to answer that question in that we don't really have anything outside of what is publicly known about that and when that will occur or if that will occur. Moving on to litigation and third parties. Will damages be sought beyond principal losses? So in some cases, we will seek punitive damages if we believe that they are likely or if we believe they are appropriate in the case. Whether or not that will be done is dependent on the facts of each individual case. And so I do believe that there will be situations that we will run into where we may seek punitive damages or other types of damages outside of just the principal amount lost. Next question. If Wells Fargo case went to court, is there a situation in which the receivership could be granted more as a settlement than the net amount the investors are missing to help cover for the cost of interest expense over the last 3 years? Yes, there are situations in which we could settle for more than just the principal amount owed, but there's a lot of factors that will go into that, and so whether or not that will occur is unknown at this point. What is the status regarding Wells Fargo and the lawsuit or mediation? So we have an expert deadline coming up of October 31st, which we will produce our expert report regarding the forensic accounting as it relates to the defendants in the case and to the overall loss in the case. That will then trigger the next piece, which I do believe will lead to a new mediation, which will occur at some point early next year. What percentage of the settlement will go to investors? So the attorneys that originally filed the case and the attorneys who work on behalf of the receivership will get a percentage of the settlement depending on at what point it settles. I believe that number goes up to a maximum of 25%. And so the rest of that money will go out once the attorneys are paid and approved by the court. Then that money will go back to investors. Any updates regarding litigation concerning banks and other financial institutions that may be complicit or investors or knew that investors were being defrauded? Again, that is going to come out of our forensic accounting work. Once the accounting is complete, we will then review the various different parties that are involved and look for potential liability, and then we'll look at filing cases at that time. Forensic accounting. Why are you not starting from the latest investors and just paying them out first? So in a receivership, receivership is a court of equity, and in a court of equity, we believe in paying everyone equally, and that's typically how this will go. The way that the claims will be done will be determined at the start of the claims process. But typically, the rule is that everybody will receive, equal amounts of the money that becomes available, or at least an equal percentage of their investment. The accounting you chose seems overly complex. Is there a reason for the route that you are going? Yes, I do wish that there was a simpler way to do this accounting. In fact, I wish there had been accounting in place when we started this case. It would have made it much simpler. Unfortunately, due to the lack of accounting records that were available, we had no choice but to start from scratch. And because of that, we had to go through and we have to look at all the different bank accounts and determine how much of the money came from investors. Our ultimate duty in this case is to figure out exactly how much investors are owed, exactly how much of the loss that was caused by defendants, and how much third parties might be responsible for of that loss. So in order to do that, we can't just estimate or we can't just take our best guess. We have to be able to prove it in a court of law. And so that's why we are undertaking the method that we are taking. This is the largest project that has been done in many, many years and is very complex, but we are nearing the end of it now and hope to have our results ready to go very, very soon. How do you plan to review and account for investors that receive back their principal? So again, that decision has not been made yet as far as how the claims process will work. Typically, the rule is that people will not get paid back any interest until after everyone's principal has been repaid. But again, that decision has not yet been made, and so we will have to continue to work through that. Once we see the how much money is owed to investors and what that looks like, we will then go through, make some recommendations to the court, and the court will ultimately decide on the process that we take moving forward. Where are we at in the process of the forensic accounting? We are nearing the end. As I stated, October 31st, we have a deadline to provide certain information to Wells Fargo. That information will be turned over at that point. There will be some additional cleanup work that has to be done on the investor side, and we will continue to do that for the few months after that, with the goal of having a forensic accounting report filed on or around the end of the first quarter of 2025. Next question is, will a final list of all claimants and their amounts be disclosed, or will you be contacted individually? We will never disclose claimants by name and the amounts that we believe that they're owed. We will reach out to individuals. We will reach out to everyone individually about the amount of your claim. Once that claims process starts, we will provide the information that we have at that time, and then we can work through what we believe the claim should be. It could be at some point we will file a list of claimants by a claim number and how much we believe their claim is, but that would be the only time that you would see that type of information disclosed. And again, it will never be by name. Clawbacks. For those investors that made money off this Ponzi scheme, will you be able to retrieve these ill-gotten gains to send back to those that had a net loss? So typically in these cases, yes, we will seek to recover money in excess of the principal amount owed to people that received additional. Whether or not who we go after and whether or not we go after them will be decided once, again, we finish the forensic accounting and determine who the net winners were and how much that money is. Why don't you go after earlier investors for money or property that they bought? Again, that decision, going after investors for money above their principal investment will be made at a later time. The claims process. Will there be any consideration given to investors who contributed funds to the Ponzi scheme within a few weeks prior to its discovery? Again, we, being in a court of equity, we attempt to treat all investors equally, whether they were invested early on and continued to roll the principal over, or if they invested right before the scheme came to light. We will attempt to treat them all equally, and again, seek to get the money distributed out to them equally as well. More questions about the distribution process. Is there going to be a disbursement of retrieved funds that will be distributed to victims within the next 3 months? I can say for certain that will not occur within the next 3 months. The goal is, though, that we will get a distribution done in 2025. We want to get the claims process started as soon as we finish the final bit of the forensic accounting. We will be filing that claims motion. The claims process, however, will be open for usually 90 days. And we will begin evaluating claims as we receive them, but we receive a lot of claims very close to the deadline, which means we will continue to evaluate them after the deadline, and it may take an additional 90 to 120 days to evaluate claims after that point, depending on the complexity of the issues outstanding. We will work with investors on a one-on-one basis if we have disagreements as to what we think the amount of their claim should be. And so that process is, it can take a little bit of time, but at the end, we want to make sure that everybody is treated fairly and equally and believes that they've been heard in response to their claim. Will investors be paid their whole principal amount? The amount that is paid back to investors will be done on a pro rata basis based on the amount of funds that are available. Whether or not we get back enough money to pay everybody in full is unknown at this time. It is not very common in a receivership case to get back 100% of your investment. However, we continue to work towards that goal, and we'll do everything we can to get back as much money as possible. Will the disbursement of funds be on a percentage of the loss each victim incurred? Typically, that is how a disbursement works in a receivership. The claims are typically done on a money in, money out basis, meaning the total amount you put in minus the total amount you got back. And then the distribution will be pro rata off of that, meaning that everybody will get an equal percentage of their claim. Now that can change. The court can decide to do a variety of different types of distribution models. Once we have figured out what all the claims are, we will present the court with our suggested distribution model based on what we think is the most fair in the situation. And then the court will ultimately then decide what that looks like. Next question is, have you been able to decide on a distribution strategy? The answer there is no, because we wait until we've received the claims in, or at least finish the forensic accounting, so we can begin to see what percentage of people got back their principal, got back most of their principal, or the percentage of people that got back nothing. And so we want to be able to evaluate that, and then we will make the recommendation for distribution at that time. What do you do, or why do you wait to issue a payment? Is holding money benefiting you or your staff? No, we get no benefit to money being held. In fact, the only way we get paid is, as I stated before, based on an hourly rate. The reason why we are not issuing a payment yet is we can't say for certain exactly who's owed how much money. We don't want to do a distribution and end up paying people that have already gotten all their money back, because then there are people that did not get all their money back who would not get all their money back. And so that would be inequitable. And so we want to make sure that we're in a position to understand exactly what everyone is owed. Again, that time is coming near, and we do think that that we will be able to start the claims process very, very soon. Potentially in the first quarter or early second quarter of next year. See, approximately how long will the recovery process take before any of my investment is returned? Once the claims process is complete, we will file a motion with the court. Like I said, it could take potentially 90 or 120 days after that process, but we will file a motion with the court. Once the court settles on the amount of the claims to be involved, we will then ask that the distribution process be allowed to move forward. And then once the court signs that, the checks will go out literally within usually a week of when the court has signed the order. So those are all the questions that we received online. I do want to, again, remind people that if you have specific questions, that you can reach us a couple different ways. One is via email at contact@jjconsulting-receivership.com. That's contact@jjconsulting-receivership.com. Or you can call 702-832-2299. Again, 702-832-2299. The other thing I recommend is, if you have not already, that you go to our website and register at jjconsulting-receivership.com. Again, that's jjconsulting-receivership.com. And if you have not already done so, please do go there and register. If you've already done so, that website is a great resource for the documents that have been filed in the case. Not 100% of all documents go up there, but the vast majority of all documents do, and all the critical documents will be found there. If you ever have specific questions about documents or are looking for something, you do feel free to reach out to my staff. I will real quick open up the chat that has been going on here and see if there's any questions that have popped up here. And if so, then I will seek to try to answer them as I can. Looks like a lot of these, let's see, how will individual punitive damages be determined? What criteria? So that is based on the Securities and Exchange Commission and the rules that they follow in various different court proceedings that have gone on. Once they, we are providing our calculations that we have done, that we're working on now. We will provide those to the SEC. What we think that the defendants are responsible for based on the SEC's criteria, and what we will provide that information. And at that point, then it's up to the SEC and the defendants what happens next. Let's see, any other questions I can answer here quickly. What is the status on recovering tithing which has been paid on ill-gotten gains? So we have been in contact with the appropriate parties there. Once the forensic accounting is finished, we will have a sit down and we'll go through that. And we do believe that the parties have already made their willingness to return that money very clear to us. And so that we do believe that that money will be recovered. What motivation does your firm have to finish the forensic accounting and a case in general quickly if you're being paid hourly? That's a very good question. We are working on multiple cases at any given time. I think right now we are working on 8 different receivership cases. The incentive to finish a case is a few. Number one, there is a holdback. As I mentioned, 20% of all of our fees are held back through the whole entire case. And we do not get those fees until after the case is closed or at closing of the case. Number two, there's a limited amount of cases that we are able to get, and so we cannot get new work until after we finish the cases that are being done. So it is really our incentive to try to get these cases moved through the process as quickly as possible. Unfortunately, as you've seen, if you've read some of the documents, some of those things are outside of our control. We try to push things as quickly as we can and continue to do so. But you would be amazed at the lack of cooperation we get sometimes from various different parties. We have had to file motions to compel people to do things that they're already required to do in the order. And so we are pushing, as hard as we can. But of course, people that involved in the case do have due process rights. And so those due process rights don't trump, the desire to get things done quickly. And so sometimes we are held back or slowed down in that process. Although we do continue to push as fast as we can and as hard as we can to get these cases closed. Is the money being collected held in an interest-bearing account for the benefit of investors? Yes, all the money that we hold is being held in interest-bearing accounts and is earning interest on a monthly basis. In our report, you'll see that in the financials, there is a section that describes interest earned, and so that information is right there. A question about claims. How can we confirm that our claim has been received? I can confirm right now that your claim has not been received because we have not requested claims yet. We have sent out 2 questionnaires to investors where we've requested certain information to help us with the forensic accounting, but the actual official claims process has not yet started. And so that will be, that process will get started, like I said, here in the near future. We're hoping end of Q1, beginning of Q2 in that time frame. What are the chances of winning anything from Wells Fargo? They're high. We think we have a great case against Wells Fargo, as do all the attorneys that are involved. As you guys are aware, there was a case filed against Wells Fargo before I even became involved, with the Securities and Exchange Commission became involved. So there are a lot of people involved in this that believe that we have a strong case against Wells Fargo, including myself. And we will continue to push our case because of that and seek to get the maximum amount possible. Are the defendants hiding money or assets? Well, we continue to look for money or assets on a regular basis. We get tips from investors, tips from neighbors and others. Every time we get information, we will do research and we will continue to look for it. The other area that we find them is in our forensic accounting. So we see the things that are being purchased. And so when we see something being purchased, we then go to look at the asset list of the things that we've taken and determine if we've taken that asset. If not, then we will investigate and determine what is the status of that asset and seek to recover it or its value from the appropriate parties based on that. So in your estimation, when will the forensic accounting be complete? So the forensic accounting, like I said, there's a first piece regarding the expert work that's required in the Wells Fargo case that will be done on October 31st. And then the finalized forensic accounting, in which we will issue in this case, will be done, we anticipate, by the end of the first quarter of 2025. Please enumerate the claims process and corresponding timelines once the forensic accounting is complete. So as we are getting ready to finish the forensic accounting and issue our final report, we will at the same time be putting together a claims motion and filing that with the court. we will ask the court for permission to begin the claims process. Once the court approves that process, typically the process will remain open for 90 days, which means that investors have 90 days to file their claims. And we will begin to then audit those claims as we begin to receive them. We don't wait until we get all the claims to start auditing them, because we're doing them on an individual by individual basis. So we'll start that process right away. And then, like I said, once we've received all the claims, we will continue to go through them. We'll continue to work with investors to the extent possible to make sure that all investors are heard on their claims. And then we will file a motion with the court with our recommendation of allowances or disallowances of claims based on our forensic accounting and the work that we've done. Investors will have an opportunity to be heard in that hearing if they think that for some reason we are not working fair or not decided their claim fairly. But again, prior to the hearing, there will be ample opportunity to work with us on your claim to make sure that you feel like it's being fairly treated. Let's see, what is the status of the case against Wells Fargo? I think we talked about that, and we'll continue to update you as we have more information on it. Right now, we're in discovery, and so the next piece of that really is related to the exchange of reports between our forensic accountant and the forensic accountant that's been hired by Wells Fargo. Let's see, any other questions that I can. Let's see here. Is it true that the claims process cannot be prolonged based on claimants not responding in a timely fashion? No, there will be a bar date that's set. And once that bar date is set, typically the court will not allow any claims after that point. Let's see. Somebody wants to talk to me about T-bills. I'm happy to have that discussion. Reach out and we can have that conversation. Will you be recovering taxes paid to the IRS? The goal is to recover taxes that were paid on false profits. It is more complicated than it might seem, but we do believe that we will be able to recover millions of dollars from taxes that were paid to the IRS. How strongly do you feel about our case against Wells Fargo? I think that it's one of the best cases that we've had against a financial institution, and I feel like that we have a very, very strong case and that we will win that case. Are you saying that the SEC is going to try to keep money for itself that will not be used to pay victims? No, the SEC does not keep money that we have recovered in the receivership estate and not pay that out to victims. The 20% number that I referenced is that so you see that every quarter our fees get approved, but what most people don't realize is that even though they're approved, we only get to pay 80% of the fees at the time. The other 20% is held back, and that's where that 20% comes in. How much money has been recovered by and held by the receivership so far? What is the approximate value of the assets that they put our hands on? All that information is available in our report. We just issued a report at the end of last quarter. There will be another one issued at the end of October. I highly recommend that you read those reports thoroughly, and all that information will be there for you to see. How do we speed this process up? The one way that I can recommend that people speed the process up is once we begin the claims process, that you get your claim filed as quickly as possible. The more claims that we can audit before the end of the process and get done means the less time we need after the process is closed, and so that will speed up the process drastically. Let's see. What is the rationale behind waiting to start and complete the claims process? Why hasn't this been completed already? In order if we had done the claims process previously, we would have required all investors to submit all their documentation to us, proving what their claim was, and we would not have had any documentation to be able to base that or to check that information against. As you might imagine, we did get a number of fraudulent claims where people claimed to be an investor in a case, and if we didn't have documentation to be able to check that against, i.e. our forensic accounting, then people would make claims and ultimately could be approved for claims for information that they should not, that they would not be entitled to because they were not actual investors in the case. So that's why we have to wait to do this process. Number two, because of the way that we're doing it now, we hope to not have to ask investors for any documentation at all. We believe that due to the forensic accounting, we will have, all or almost all the information we need ahead of time. And so it will streamline that process significantly and make it go much faster and much, much less expensive to process. If we are investing through different entities, will we need to submit claims for each separate entity? That decision has not been made yet, but we will make sure that that is clear upon the claims process. Oftentimes, if you invested through different legal entities, we will ask you to file a separate claim for each of those entities. But again, that final decision has not been made yet. And once it does, we will make sure that information is available. A couple of questions I see about specific facts about the Wells Fargo case. I would encourage you to read the complaint that we have filed against Wells Fargo, and that will give you the most information about that. We provide a preferred form for claims to be filed. Yes, we will have a claims form that we will use that people will submit. We will set it up electronically, so that we hope to get the vast majority of the claims done electronically to simplify the process, speed it up, and make it less expensive. Does the Wells Fargo case have to be done before monies are distributed? No, we can actually start the distribution. Once the distribution plan is approved, we will distribute money that's available at that time. And then once the Wells Fargo case settles or it gets litigated and we get an award, then that money will be distributed separate from that if it does not happen, if that money is not available at the time that we make the first one. The claim filed against Wells Fargo should be available on our website. I will ensure today that is there if it is not already, but I do believe it's there, and so that you can get on and see that yourself. Looks like the last question: what is the process for punitive damages for an individual? I don't necessarily understand that question. Punitive damages against an individual, that would just be based on the litigation and whether or not it's appropriate based on that litigation. Punitive damages are hard to get, but not impossible. And of course, in any situation we believe they're appropriate, we will attempt to do that. Are you working full-time on just this case? No, there are a variety of different cases that we work on. Now, there are some of our staff, especially on the forensic accounting side, that have been working full-time on this case and to the exclusion of anything else. But of course, that will change as the forensic accounting wraps up. But the operations side of my staff spends time working on a multitude of different cases, and even a couple of the forensic accountants do some work on some other cases from time to time. But we have made the forensic accounting a priority. We've shifted a bunch of resources that direction. And so over the last couple of quarters, that has been the big push as we've finally gotten the documentation that we needed in order to be able to complete the process. So again, so the last question, if you complete the claims process now, you can be ready to compare it to your forensic accounting there for expediting the process, correct? No, I wish it was that simple. The problem with the claims process is we have to decide how we're going to do it before we request the forms. And so because we don't have all the information yet, we don't know what we would need to request at that time. And we would risk people submitting a bunch of documentation. So investors would spend a bunch of time going out and getting documents that we already have, or that may be at some cost to investors where they may not be able to find. Since we have to do the forensic accounting anyway to prove our damages in these third-party litigation cases, including Wells Fargo, our hope is to simplify the claims process for claimants themselves. So that's all the questions that we have that have been posted to date. I hope that I did not miss any questions, but I apologize if I did. Again, I want to reiterate, if you have specific questions, please reach out to us, contact at jjconsulting-receivership.com or 702-832-2299. Thank you guys for allowing me the opportunity to speak with you. Again, if you have specific questions, do reach out. Otherwise, just know that we are pushing as hard as we can and as quickly as we can to get this done. I know it doesn't always feel that way from your perspective, but please know that we are doing everything we can to get it done quickly. Thank you.